Good morning. I think we're going to go ahead and get started. I'll have Ms. Taylor check with AT&T and see if we're all set. Looks like we got a thumbs up here. Well, good morning to my fellow members and to the work group participants and the public watching. We'll have several people on Zoom and some here actually in person and live this morning. But before we start, I just want to get some introductory remarks and have Ms. Taylor please call the roll. And then we'll have her make some safety and informational announcements, and then we'll call the first item. Ms. Taylor.
Excellent. Good morning. We'll start with the roll call. Chair Lieber. Here. Vice Chair Gaines.
Here.
Member Vasquez.
Present.
Member Schaefer. Deputy Controller Emron.
Present.
A quorum is present. Our first order of business is our safety and informational announcements. Welcome to the May Lee State Office Complex. First, I would like to remind the audience to silence their cell phones and other wireless devices. Our safety announcement. In the auditorium, the exits are located on each side of the stage at the front with additional exits at the rear. Please take a moment to locate the exit sign and the closest exit to you in the event of an emergency. This board meeting will be live streamed to the public and posted on the BOE website. Public comments are taken on each agenda item. If there are any members of the public wishing to speak before the board on any agenda item in person, we ask that you complete and submit to the Sergeant at Arms a public comment appearance sheet located at the entrance of the auditorium. If you wish to speak before the board by telephone, please dial the phone number and access code provided on our public agenda notice and follow the instructions of the AT&T moderator. When giving public comments, please limit your remarks to 3 minutes. We also ask that all speakers in the auditorium or on the AT&T telephone line to state their names before speaking on the record. That concludes the safety and informational announcements. Thank you.
Thank you, Ms. Taylor. And I want to just, for those that might be listening or watching this on Zoom, we have everybody here present, and from my understanding, Member Schaefer will be on Zoom himself, I believe, or through Teams. I don't know what.
Yes, Member Schaefer may appear later this morning, and when he does come on to the remote Teams environment, we will need to take a short. We don't need to take a recess, but I do need to ask him a question before he joins. So I'll let you know.
Thank you. I want to welcome everyone as we convene the third meeting of the AAB and Assessors Issues Board Work Group. We have a dozen participant and officers represented here today, many of whom are returning back from some of our previous meetings to discuss 3 topics. And we look forward to their insight and perspectives. Before we start this first panel, I want to make a few comments about the work group and how the meetings have been going so far. The first 2 meetings of the work group resulted in a significant amount of testimony and knowledge sharing from the assessors and the various parties involved in the assessment appeals process. The discussions have addressed a wide variety of issues and have created administrative delays for assessors and AABs, including the assessment appeals process and the refund process. The incorporation of new technology into these processes and the administrative impact of Prop 19. As a result of these work group meetings, the board has, among other outcomes, 3 of the following, which I'll mention here: extended existing educational materials to the county clerks and the AAB members. 2, approved and published guidance in response to specific issues and concerns. And 3, identified issues which would require legislative change or long-term commitment and collaboration while deepening our understanding of those issues and engaging with relevant stakeholders. We greatly appreciate the contributions of our participants, the executive director, the agency staff, and everyone involved who have contributed to the success of this work group so far. And we are hopeful that the specific topics for today's meeting can lead to additional concrete outcomes to assist in the work group goals. Topics for today: In light of the testimony gathered at the first two meetings, the work group has decided to focus on three specific topics at this meeting today. To facilitate the fullest discussion at today's meeting, I have provided descriptions of the topics in PAN materials, which all members were provided. These topics consist of possible ideas and suggestions which would have arisen to address administrative concerns, but which require additional input from all parties. The topics for today consist of: 1, possible amendments to the assessment appeals application form. Work group testimony established that the form as currently constituted may create confusion for taxpayers, which in turn can create administrative burdens for counties as they work to resolve appeals and issue refunds. Our hope is that the testimony today can identify sections of the form which can be improved, as well as areas of consensus to begin a possible reconsideration of parts of the assessment appeals form if appropriate. 2, possible BOE guidance on factors for AABs to consider in the making decisions on postponements and continuance of cases. Work group testimony established that the continual granting of postponements or continuance can create backlogs in the scheduling of the AAB matters. The concept of good or reasonable cause for a postponement or continuance is a legal term, and not all AAB members have a legal background, and counties have varying levels of immediate access to county council or AAB hearings. One work group participant proposed a list of AAB-specific factors to be considered in making these decisions. This list can be found in the PAN materials. My hope is that by receiving input on these factors from the participants, that areas of consensus can form the basis for new guidance aimed at helping AAB members identify when the postponement or continuance is not as likely not justified. 3, possible BOE guidance on encouraging scheduling coordination between assessors and AABs. Work group testimony established that the appeal scheduling practices can create administrative burdens on the AAB process. As both county assessors and AAB clerks are involved in every appeal, in different roles, it is important for the relevant parties to coordinate or communicate to certain extent. One work group participant proposed revised guidance from the BOE to encourage greater cooperation between county clerks and assessors to reduce or minimize administrative barriers. Our hope is that by receiving input on this proposed language from the participants, we can find areas of consensus for the BOE to encourage the optimal level of scheduling coordination between the county clerk and the assessor. Proceedings. Regarding the format of the meeting, we have 3 panels of participants who will be presenting today. First one will be county clerks and AABs. The second one will be the county assessors. And the third one will be taxpayer organizations. We will receive a mix of remote and person testimony. Each panel will begin with the participants given an 8 to 10 minute presentation on all 3 topics, dividing their time between the topics as they prefer. Once all panels participants have presented, there will be a time for board discussion and Q&A, followed by the time for public comment. My goal is that the format will be the most conducive to a fruitful discussion. As each participant, many discuss each topic, I have provided note pages with the PAM materials to assist the board members in keeping their comments and questions organized. With that, I want to thank you all again and welcome with those opening remarks. And let me turn it to my fellow colleagues and board members to see if they have any opening remarks. I'll start with our chair.
Excuse me, Member Vasquez?
Oh, yes.
I believe that Mr. Schaefer has joined the meeting.
Okay. I see him on the screen.
All right. Mr. Member Schaefer, Can you hear us?
I think he's muted.
Yep.
Oh, yes, I can hear you fine, thank you.
All right, thank you. I do have a question, a statement. Member Schaefer is appearing remotely. If a member of the board attends the meeting by teleconference from a remote location, the member shall disclose whether any other individual, 18 years or older, is present in the room at the remote location with the member and the general nature of the member's relationship with any such individual. Therefore, Member Schaefer, is there anyone 18 years of age or older present in the room at your remote location?
Yes, I have Dr. Cody Pedersen in the room with me. He's my chief of staff. He's here on official business.
Thank you so much. Back to you, Mr. Vasquez.
Thank you, Ms. Taylor. With that, let me go back to my chair.
Thank you so much, Mr. Vasquez, and I wanted to extend my thanks for all of the work that you have personally put into this process, as well as your staff. I know it's been a very thorough dive into the subject matter, and I appreciate all those who have taken part in the process over the previous meetings. I've taken a lot of notes, and I think those will be very helpful as we synthesize everything that we've heard. And I know that your goal, as is mine, is really to facilitate a system that works for all taxpayers, both large and small, and to illuminate some of the issues, even where we don't strictly have jurisdiction, for example, over the clerks and collectors, but to really highlight what's happening for taxpayers in terms of review of their assessment and also in terms of getting timely refunds. So again, I thank you for presenting this to us, and I look forward to the testimony that will be provided today.
Thank you. It looks like our deputy clerk, go ahead, or controller.
Thank you, Mr. Vasquez. Good morning to you all. On behalf of our great state controller, Malia Cohen, I'm excited to be here. I think it was just about a year ago, February 2025, we decided to take this journey. So I want to thank the county representatives, taxpayer advocates, and stakeholders for joining us today. And now we're several work groups in, and I want to begin by acknowledging the depth and thoughtfulness of the testimony we have received over the past year. I found that there is a remarkable degree of consensus that while our assessment appeal system is fundamentally sound, it faces persistent operational challenges, particularly around training, application, clarity, scheduling, coordination, and the consistent application of good cause. What we have heard clearly is this: many AAB members are being asked to make complex procedural and quasi-judicial determinations without uniform statewide guidance or ongoing training. Counties are navigating scheduling coordination challenges that require balancing efficiency with neutrality, and applicants, especially self-represented taxpayers, often struggle with technical application, language that can unintentionally lead to delay or confusion. Our responsibility here as a board is not to micromanage county operation, nor is it to tilt the process one way or another towards the assessors or taxpayers. Rather, our constitutional role is to promote fairness, uniformity, and confidence in California's property tax system. That means asking the hard questions. Are delays driven by unclear standards? Are continuances being granted out of caution rather than clarity? Is information exchange occurring early enough to prevent compounding backlogs? And can better statewide guidance and training reduce unnecessary friction without limiting due process? Today's discussions is an opportunity to move from identifying challenges to considering targeted practical improvements. I look forward to hearing from each panel and continuing this collaborative effort to strengthen the integrity, efficiency, and fairness of the assessment appeals process statewide. And I want to welcome everyone here today. Thank you.
Thank you, Vice Chair.
Great. Yeah, thank you. It's great to be here and to learn. I think, number one, we want to cause no harm. So my hope is that by these gatherings that we provide some guidance, or actually, in a sense, a forum for discussion with the county assessors. And of course, the county clerks, for which we don't have jurisdiction over, but I think we can have some great discussion and hopefully come up with means of providing counties with a more efficient means of how to make sure that we're serving the needs of our constituents when it comes to an appeal coming before their boards. And so I look forward to it, and I'll be taking notes and listening, and hopefully we can come up with something that has some level of uniformity. And I know that's always a challenge when you're dealing with 58 counties. So look forward to it. And thank you for leading this effort, Member Vasquez.
Thank you. With that, let me turn it back to Ms. Taylor, and if she could please call our next item.
All right. Our next item is item number 2, panel number 1. And during this panel, they will discuss the following issues: consideration of possible recommendations on amending the assessment appeal application, developing factors for AABs to consider in good cause, reasonable cause determinations, and developing guidance on scheduling coordination between county assessors and county clerks. Did you want to introduce the speakers, or would you like me to introduce the speakers?
You know what? I'm going to ask you, because I'm looking at my notes, and I know I see Ms. Moore here present, but
Yes.
I don't know who's on remotely.
All
Or
right.
at least it's not on my notes here.
So in person, I'll ask Ann Moore, Assistant Clerk of the Board of Supervisors, San Diego County, to come forward. And I believe the rest of our participants for this panel are on teams. That is Thomas Parker, Principal Deputy County Counsel, Property Division, Office of the County Counsel, Los Angeles County. Jennifer Tran, Assistant Executive Officer, Executive Office of the Board of Supervisors, Los Angeles County. Brendan Vlachis, Chair, Assessment Appeals Subcommittee, California Clerk of the Board of Supervisors Association, and the Assistant Chief Deputy Clerk of the Board, Ventura County. And Leslie Pack, Deputy County Counsel for the Assessment Appeals Board, Santa Clara County. You are welcome to turn your cameras on and unmute, since this is a panel discussion.
Thank you, and I see Ms. Moore here in person, so why don't we go ahead and start with you first.
Good morning. I'm Ann Moore, Assistant Clerk of the Board for the County of San Diego, but I'm here to speak on behalf of the California Clerks of the Board Association. So thank you to the honorable members of the board for this opportunity. And thank you for the ongoing collaboration between the Board of Equalization and the California Clerks of the Board of Supervisors Association. We truly appreciate the thoughtful engagement that we've had with your staff over the past several weeks. We also want to express our appreciation for the collaboration of the other participants in this process, including our partners from the Assessor's Office and from CADA. We recognize that all of us, regardless of our individual roles, are working towards the same end goal: a fair, efficient, and accessible assessment appeals process that serves taxpayers well. The open dialogue over the last several weeks has been extremely valuable, and we are grateful for everyone's willingness to bring forward ideas, concerns, and practical perspectives. Members of our Assessment Appeals Subcommittee met internally after our discussions with BOE staff to evaluate the proposed concepts and language, and the comments I'm offering today reflect both that review and the practical experience of the clerk's offices across the state. I'd like to begin with topic 1, which is the amendments to the assessment appeals application, because the application is one of the documents that every applicant must interact with, and sections 5 and 6 continue to be the most common areas where taxpayers struggle. Across county, clerks consistently see the same patterns. Applicants check too many boxes, or not enough boxes, or boxes that can't be checked together, or they select a reason that doesn't match the assessment they're appealing. And these issues overwhelmingly stem from confusion, not carelessness. I also want to share something anecdotally that emerged during our subcommittee's own review. When we sat down as a group and walked through certain filing scenarios, even our most experienced appeals clerk did not always agree on how sections 5 and 6 are meant to be interpreted. If the people processing these forms every day can reasonably arrive at different interpretations, it's no surprise that applicants struggle. This is exactly why CCBSA strongly supports expanding and clarifying the inline instructions within these sections. Our recommendation is to embed plain language guidance directly into sections 5 and 6, so filers can more readily understand the type of assessment they're appealing and the specific reason for their appeal. Improving clarity at the point of selection will significantly improve accuracy for first-time filers, reduce administrative burdens, and help ensure that applications are complete when they're received. We also want to briefly acknowledge the idea of creating a simplified or alternative application, for example, an additional shorter form for single-family residential properties. While well-intentioned, this approach would introduce new complications. Before even filling out the application, applicants would now need to determine which form applies to them, and counties, particularly those using custom software, would face substantial costs and operational challenges to support multiple application pathways. The length of the application isn't the issue. The instructions and applicants' understanding is, and that's where targeted improvement will be most efficient and most impactful. Touching on good cause determinations, we appreciate the work BOE staff has done to develop potential guidance. We believe that the clear, structured advisory set of factors will be extremely helpful to AAB members, particularly those without legal training. Many AAB members are skilled professionals, appraisers, accountants, and real estate experts, but as we've discussed before, good cause determinations often involve legal analysis, procedural judgment, and consideration of statutory timelines. A well-crafted framework will support greater consistency and confidence in these decisions across counties. That said, guidance must remain flexible. Every appeal is different, and AABs must retain discretion consistent with their quasi-judicial role. We have recommended 2 clarifications: acknowledging the county's specific considerations and reinforcing alignment with Property Tax Rule 323. These suggestions ensure the guidance remains practical, legally grounded, and sensitive to the differing needs and resources across counties. Overall, we see this as a strong resource that supports AAB members while still preserving the necessary case-by-case discretion. And then finally, I'd like to address scheduling coordination. Clerks manage scheduling with great care, balancing assessor availability, appellant schedules, statutory timelines, hearing officer calendars, and county staffing resources, often simultaneously. We've reviewed the proposed language from BOE staff regarding assessor scheduling needs, and we have significant concerns with making this a mandate. Clerks already coordinate with assessors as a practical matter. We understand and respect that assessors face the same staffing and resource challenges that we do. And in many counties, the working relationship between the clerk's office and the assessor's office is excellent. However, requiring clerks through guidance or rule to prioritize assessor preferences risks undermining the clerk's neutrality. If assessor preferences are mandated, professional tax agents will understandably request equal consideration, and applicants may do the same. That scenario places the clerk in the difficult position of arbitrating between multiple competing interests, which is precisely what leads to delays and administrative strain. We also want to reiterate that the existing guidance is already sufficient. LTA 2013-039 and Property Tax Rules 307 and 323 provide clear, long-standing direction on calendar management. If the board determines that further clarification is necessary, we respectfully recommend using permissive language such as may take into account rather than mandatory language such as must or shall. This preserves the clerk's office ability to manage calendars in a way that reflects the most pertinent factors for their particular county while still recognizing that the coordination with the assessors can be appropriate when circumstances allow. Across all 3 topics, our focus is grounded in the same principles: improve taxpayer understanding and reduce confusion, strengthen statewide consistency, protect the neutrality of the clerk's office, and avoid unintentional operation or technological burdens. We deeply appreciate the opportunity to participate in this process and the thoughtful engagement from BOE staff, the assessor's office, and CADA. CCPSA remains committed to working collaboratively with all of our partners to improve the assessment appeals process in a way that benefits taxpayers and counties alike. And one final thing that I'd like to add from my role as Assistant Clerk of the Board in San Diego County, I want to thank your team's work on an item that isn't on the agenda. The recently published LTA clarifying e-signature guidance has been tremendously helpful in moving forward conversations with our county council on implementing e-signatures. So we want to express our appreciation for that. Thank you very much for your time today. We appreciate it.
Thank you. Now that I found my notes going back, and I know we have online right now, is from the AAB's county clerks, which is Mr. Parker, who has provided testimony before us several times, especially on this work group. It's been very valuable and very helpful, and I see him on the screen. So, Mr. Thomas Parker, if you, oh, I'm sorry, go ahead.
I'm sorry, Yvette Stowers, Executive Director. I just wanted to correct the record. This is a work group, so you've been interacting with not BOE staff, but the member staff, except for the LTA. Just wanted to correct the record on that.
Thank you.
Just a question of clarity.
On,
Can we ask questions?
yes, what I was trying to do is, after all the panelists speak, we'll do the Q&A. I'll
Okay.
turn it over to
Very
you
good.
folks.
All right,
If you
thank
could
you.
just keep note of, yeah, make
Okay.
note of anything you have.
Sure.
And I see Thomas Parker on the screen. If you want to go ahead and start with your remarks or comments.
Thank you, Mr. Vasquez, and honored members of the State Board of Equalization. Thank you for, as well, on behalf of the CCBSA, for your efforts to try and improve the process for everyone involved in it. I certainly endorse everything Ms. Moore just related to you as a representative of the CCBSA. I would just try and add a little bit of gloss, if I could use that term. Regarding amendments, I think I certainly agree that to some degree, it's unavoidable, but hopefully there is some of it that can be avoided. The technical language in the appeal application regarding sections 5 and 6. I think I would add as well that whatever changes to 5 and 6 come out, we need to make sure that we are merely clarifying in plain language, or as plain as possible, the intent behind sections 5 and 6 of the current application form. Because anytime you make changes, the law of unintended consequences might create new challenges for future applicants and future clerks down, and maybe even assessors' offices down the road. So we definitely need clarifying language. We need to make sure that we don't create unintended consequences to the extent that we can foresee the future with our broken crystal balls that we all work with. Regarding topic 2, it's always good to have guidance, suggestions, not mandatory, but suggesting guidance for good cause, good/reasonable cause regarding postponements and continuances. It's a very fluid situation and with continuances and postponements. By that, I mean the nature of the appeal, that is, say, the property, the amount of money at issue, the type of information, and the amount of information needed in order to have a fully informed assessment appeals board meeting is going to vary from case to case, from a practical viewpoint as well as from a legal viewpoint. And I would just, the greater the clarification, and I, as a lawyer, think it's important in any additional guidance that the state board might include on when continuances or postponements ought to be granted is being considered. It is important to acknowledge in that guidance Rule 323, so that, which has been on the books for some years now, and just to make sure that everybody doesn't forget that inadvertently. Regarding schedule coordination, That's a really interesting balancing act in my view. I've been both assessor's counsel for 16 years, and I am now entering my 16th year as an AAB counsel for one county or another. I give that just as context for saying that your assessment appeals board manual properly notes that there should be some degree of consultation between the county clerks and the auditor's office. And that's based on a very practical and important consideration, which is the assessor is a party in every appeal. Not every private party is a party in every appeal that the AAB is going to hear over the years. But it is also important to balance with that what Ms. Moore said earlier in her comments. That is to say, this is a quasi-judicial proceeding. AABs must be objective and neutral, not only in considering the evidence that is being presented and weighed by the AAB, but also in terms of the scheduling. Because an AAB hearing is only as good in many ways as how well informed it is in terms of the evidence presented to it. Just like computers, if you put bad information in a computer, you get a bad computer result. AABs, in my view, are much the same. If the AABs don't have all the relevant information in order to make an informed decision, the decision may not be the best decision. But that, to me, is not the fault of the AAB itself. It's the fact that they didn't have all the information available from both sides to be presented, to be cross-examined, and then to be weighed by the AAB. So continuances and postponements have been built into this system since the 1960s, and they are important aspects of the system. They should not drive the system in and of themselves, but this, in my view, is a tricky balancing act, and therefore we need to be careful about, as Ms. Moore mentioned, always recognizing that as a quasi-judicial body, the AAB has to weigh postponement and continuance requests in light of the context of the particular appeal. And to conclude on schedule coordinating, I digressed a little bit, I apologize to the board. The scheduling coordination is a three-party process in many ways. But the ultimate decision, as I have urged many times upon the State Board of Equalization, it's ultimately up to the AAB as a matter of law to decide when things get scheduled, as well as whether they're virtual or in person. And so the AAB is the party that ultimately has to balance the scheduling needs of appellants and the assessor's office. And I'm glad to take any questions later on at the appropriate time. Thank you.
Thank you. And let me go with our second speaker, which is Jennifer Tran, who's also from the LA County Board of Supervisors. Ms. Tran has also participated in previous meetings and has brought data focused perspectives on the AAB process in LA County. And I see her on the screen. If I could just have you go ahead and open up with your comments and remarks. Welcome, Ms. Tran.
Thank you. Good morning, honorable members of the board. My name is Jennifer Tran, Assistant Executive Officer for LA County Board of Supervisors Executive Office. On behalf of our Executive Officer, Mr. Edward Yan, I thank you for this honor to speak with you today and the opportunity to provide feedback and recommendations to help improve the assessment appeals process. On the topic of amendments to the assessment appeal application, Last fiscal year, LA County received nearly 18,000 assessment appeals applications, of which 55% were filed manually and 45% were filed online. We recently conducted a time study on the online submission process and discovered that on average, an applicant without agent representation would take approximately 15 minutes to complete and submit their online application. During the same fiscal year, we also received nearly 2,600 telephone inquiries, of which 5% were calls with questions on key terminologies listed on the application, including the type of assessment being appealed under Section 5 and reason for filing an appeal under Section 6. Therefore, LA County AAB has the following recommendations for your consideration. First, use plain and simple language with key terms and definitions on the instructions on how to complete and file an appeal to avoid confusion. It is also recommended to include a high-level overview of the appeals process. Second, place the information and instructions for assessment appeal application at the front or before the application form itself to provide clear and upfront guidance that will help reduce mistakes and incomplete submissions. Additionally, having the instructions at the front of the form will also help the applicants determine if they would prefer to file the appeal themselves or to obtain professional tax agents to file the appeal on their behalf. However, while LA County is still exploring finding a solution to replace or enhance our legacy system, any changes on the application's fields or questions will require additional resources to redesign and reprogram our current system, which may be challenging due to our current budgetary constraints. As such, it will be more beneficial to revise and improve the instructions rather than changing the application's fields or questions. However, if the state board decides to pursue changing the application's content, we would like to present the following suggestions for consideration. First, on the applicant information under Section 1, we recommend adding the preferred method of contact, for instance, mail or email to receive their correspondence or notification. Second, on the contact information, agent, attorney, or relative of the applicant under Section 2, we suggest adding a checkbox to identify the relationship to the applicant, such as agent, lawyer, corporate officer, or relative. Lastly, the claim for refund question should be placed after Section 2 to help minimize erroneously skipping or unmarking of this section. On the topic of factors for AEBs to consider in good or reasonable cost determinations, during last fiscal year, 24% from nearly 36,000 scheduled applications were postponed, which already represents a 33% decrease in postponement requests compared to fiscal year 2022-23 that can be contributed to our hybrid appeals hearing platform. In LA County, the postponement request form can be submitted manually or online. As such, we respectfully recommend to the board to implement a statewide postponement request form to create consistency in format and application of rules and requirements, including a certification section to certify that the information is true and correct under the penalty of perjury. Lastly, LA County agrees with the proposed language listing the facts and circumstances that the AABs may consider when granting postponements and continuances. On the topic of development of guidance on scheduling coordination between assessors and county clerks, as I shared from prior testimonies, the scheduling coordination and collaboration between the AAB and the assessor's office has greatly contributed to the dramatic closure of LA County's backlog appeals. However, I would like to emphasize that AAB maintains full control over scheduling. We regularly meet with the assessor to prioritize the scheduling of appeals based on AAB's data or analytics, which may include open appeals based on property type of issues appealed on, and region. Additionally, AAB shares open, scheduled, and closed appeals information to the assessor through an automated data interface on a nightly cycle. However, please note that one size does not fit all, since each county has its own workload and unique needs to consider. As such, we respectfully recommend that if the board decides to establish additional guidelines to property tax rules 307 and 323, it will be beneficial to use discretionary language that will provide the AABs the flexibility to determine the approach that is appropriate to their operational needs. And this concludes my presentation. Again, thank you for allowing me to address your board. I appreciate your time and the opportunity to share LA County AAB's perspective. Thank you.
Thank you. And we'll come back to you with, I know we have some comments and questions, but let me move on to our third speaker, which, and looking at my notes, I guess I was supposed to combine it with Ms. Moore. So let me, and I see, I think Brandon is on the screen. I see him up there as well.
Yes.
Velakis, he's the chair of the subcommittee, California clerk of the Board of Supervisors Association, and assistant chief deputy clerk of the Board of Ventura County. I wanted to also mention, and he has committed a great deal of time and work to this work group and has been very helpful in allowing our work group to connect with the county clerks on these important issues. My understanding that the next speaker, which was going to be combined with the two, we've already heard from Ann Moore, so let me open it up to Brendan, if you can go ahead and give us your comments and suggestions.
Thank you. I'll be brief. Good morning, members of the Board of Equalization. I'm Brendan Vlahakis, participating today on behalf of the California Clerk of the Board of Supervisors Association. As stated by my co-chair, Ann Moore, she is serving as our representative this morning. I remain available should you have any questions, but will primarily defer to Ms. Moore as CCBSA's representative for today's proceedings. Thank you.
Thank you. With that, let me move on to our fifth speaker, which is Leslie Pack. I think I see her on the screen as well. Deputy County Counsel for the Assessment Appeals Board from Santa Clara. And first of all, she's here actually from the AAB from Santa Clara County. While this is Ms. Pack's first time on our work group, it is not the first time that we've heard from the County Council from Santa Clara. They have been providing thoughtful and important input at our previous meetings. So welcome, Ms. Pack. I know you've had some big shoes to fill over there in Santa Clara and really appreciate you joining us today. We'll turn it over to you.
Thank you. Good morning, honorable members of the State Board of Equalization. Thank you for the introduction and for the opportunity to participate in today's work group. I will be addressing all three topics today, starting with the potential amendments to the assessment appeals application. To address the issues that are often raised by the application, the hearing clerks in my county have assembled a list of common areas of confusion among applicants related to the application. To stay within my allotted time today, I'll just share a few examples from that list, but I would be happy to submit the full list if the board would like to see it. Some of the examples that the clerks have identified are items that are already addressed in the application instructions, but still raise questions among applicants. And so we believe that for these issues, the instructions could be fleshed out to provide more of an explanation to address the most frequent misunderstandings. As an example, in section 4, where applicants can list their enrolled values or opinions of value, the instructions advise them that they need to list the values from the assessment notice or tax bill that they're appealing on. But applicants sometimes don't understand what the term improvements means and think that they are being assessed for construction they haven't done and file new construction appeals. Similarly, in section 6, where applicants can check off their reasons for filing an appeal, there are options to appeal the assessor's classification of their property or the allocation of their property's values. And these boxes often get checked because applicants don't often know what the term classification or allocation means with respect to their assessments. And so they check those boxes to avoid waiving any claims that they may be eligible for. Also in section 8, where applicants can designate their applications as a claim for refund, the instructions do explain that refund claims affect the time period for filing suit in Superior Court, but it could be clearer within the instructions that the claim for refund does not affect whether applicants will obtain a refund of their property taxes if the AAB decides in their favor. So those are a few areas where the existing instructions could potentially be fleshed out some more. In addition, there are some issues that are not addressed by the instructions currently. One of those has to do with personal property appeals. Our hearing clerks often get questions from applicants, including agents, about whether they need to check the box in section 6 to appeal a decline in value or to appeal the assessor's valuation of their personal property and or fixtures, which is a separate issue in section 6 to check. Another issue in section 6 that applicants often don't understand is construction in progress. They often don't know how construction in progress is assessed. So when they intend to appeal the base year value of their new construction, they often add selection in progress just to cover their bases. So these are just a few examples of areas where some additions and clarifications to the instructions could be helpful. But we realize that additions to and clarifications of the instructions have to be balanced against an interest to avoid cluttering the instructions. Because we've also found that sometimes applicants don't read the instructions, and that may be because they are discouraged to see a large volume of fine print and perhaps would be more likely to read the instructions if they were shorter and in larger print. So to that end, one suggestion we have is to review the form and instructions for some less useful content that could be removed. So as an example, within my county, the clerks often actually do not need a bill number, assessment number, or DBA from the applicant for purposes of processing applications. And if that's true of other counties, then removing those fields and fields like it could create space on the application to move some of the more critical instructions from the attachment onto the main body of the form, where they would be less likely to be overlooked. An example of that would be the instructions to penalty abatement appeals. Currently, the instructions are pretty clear that penalties levied by the tax collector cannot be appealed to the AAB, but we still receive appeals for late payment penalties. And so moving the instructions concerning those abatement appeals onto the main body of the form could help reduce the number of applications that our clerks have to review and ultimately reject. Moving on to the issue of good cause and reasonable cause for postponements and continuances, we are generally in agreement with the proposed guidance, assuming that it's advisory rather than mandatory. And we have 3 additional considerations to suggest in terms of what AABs can take into account in determining good cause or reasonable cause. The first is the applicant's willingness to waive the 2-year limitation to hear appeals. Currently, under Property Tax Rule 323, waivers of this limitation period are mandatory under certain circumstances, such as when an applicant postpones for the first time within 120 days of the period's expiration. But we believe it would also be appropriate to consider the applicant's willingness to sign a waiver in instances when the board has more discretion to allow a postponement or continuance. We also suggest adding a consideration of whether a postponement or continuance will allow either party to provide information that the board determines is necessary or appropriate for purposes of deciding the appeal. And third, we suggest adding a consideration of the reasonable needs of the Assessment Appeals Board or hearing officer. Currently under Rule 23, this is a basis for allowing a continuance for longer than 90 days. And we believe it should also be a factor to determine reasonable cause for a continuance more generally. And finally, concerning scheduling coordination between assessors and county clerks, my county's clerk of the board has provided a written submittal. But because of the timing of that submittal, I would like to provide a high-level overview of their comments. Specifically, they were addressing the proposed guidance to consider the assessor's staffing levels and workload when scheduling appeals and to adopt the assessor's recommended hearing dates whenever feasible, provided that the schedule does not create a prejudicial pattern in favor of the assessor's office. So the remarks from our clerk of the board note that considering the assessor's staffing levels and workload is not feasible for them. Currently, the way that the scheduling process works is the assessor's office provides the clerk of the board with the months in which they will be ready for hearing, and the clerk of the board takes this date into account along with other factors, including the type of property at issue under the appeal, whether applicant has opted for a hearing officer, whether there are other pending appeals for the same property and which boards those are scheduled before, and which boards and hearing officers have heard appeals of the same property in the past. So these are just a few examples of what they have to take into account, and they're doing this for thousands of cases a year. And they do not have the staffing levels to also factor in the assessor's schedules and workloads. They also note, as have other speakers, that the clerk is a neutral third-party administrator of the assessment appeals process, and they are not able to afford the same level of consideration requested by the proposed guidance to applicants when appeals are being scheduled. Applicants are not given the opportunity to recommend hearing dates, so deferring to the assessor's recommended hearing dates would inherently give an advantage to the assessor. Another point raised by the clerk submittal is that although the proposed guidance is intended to address prejudicial patterns that may emerge, the clerk of the board has no way to detect or prove that a prejudicial pattern actually exists. Again, the clerks handle a large volume of appeals, and for any given appeal, there is a range of potential outcomes, as well as multiple potential reasons to favor one panel or hearing officer over others. So given all this data, determining whether a prejudicial pattern exists would require analytics that the clerk of the board does not have access to. In addition, if they cannot schedule appeals at their own discretion or even randomly, there's no baseline for comparison to see if a prejudicial pattern exists. So therefore, however unlikely it would be that staff would attempt to abuse the proposed scheduling process, the reality is there would be no meaningful checks on that process. And so for those reasons, our clerk has respectfully objected to the proposed guidance regarding scheduling coordination. And that concludes my remarks, and I'm happy to take questions during the allotted question period.
Thank you. And thank you for your presentation, Ms. Spock. And before I move on to my questions, I understand that Mavani, who contributed to our past work group meetings, was recently appointed as the court commissioner in your county. Please extend the work group's congratulations to Mr. Mavani if you have the opportunity down the road.
Certainly, I will do that, sir.
Thank you. Let me start, first of all, thank all the folks for their comments and suggestions that we received today. I have several questions. I'm just going to start with two, and then I'll turn it over to the members. And if they don't address some of the other issues I have or concerns or comments, I will bring them back. The two that I want to raise, and this is for any one of the speakers, including Ms. Moore here present, is on the topics on the AAB application for the refund and the simplification. Some of you kind of touched on it in your remarks, but on the refund, one of the original 4 work group topics, which was exploring ways to improve the efficiency of the refund process following a successful appeal, to the extent that the appeal application itself may not be the right place to gather more information about the possible refund, when do you believe would be the best place in that process to consolidate the necessary information? And I open it up to any one of the speakers.
Mr. Vasquez and members of the board, I'll take a shot at that one.
Thank you. Go ahead, Mr. Parker.
I would say that over time, information can change. What I mean by that more concretely is we have had appeals, certainly in Los Angeles, where a business entity was owned by a certain number of shareholders or individuals when they filed the appeal. But by the time the dust settles and the appeals process has said, yes, there is a refund of whatever amount of money due, ownership of the property has changed hands. And the AAB is not in a great position to note the change of ownership between the filing of the appeal application and when the resolution of that is done, such that the auditor controller is now potentially processing refunds. So that is a very practical issue in terms of, I cite that as an example and to show you that the AAB is not necessarily in a great position where it is to know down the road which party is going to get the refund of whatever amount and who that party should be. And you run as well into the problem if you try and beef up the application in some way to obtain more information up front, which is logical in some ways. Now you're potentially making the application more complex, and that's not what the CCBSA is recommending to the state board for the reasons we've all stated. It might be helpful if there was some guidance that could encourage parties who are appealing, whether they're personal or business, to put a sort of a duty or obligation on them to update the county. And I'm not sure which office it should be, but maybe the assessor, for instance. And the assessor may or may not agree, I don't know, but I'll pick on them for a moment. To inform the county through the assessor's office that something has changed, such that if there is a refund 2 years down the road, the county will know that who the refund should go to and have an address and a name. That's one possible thing to at least think about. But we want to be careful in terms of the application, not to treat the application as the means to necessarily address your concerns, sir. That's my view anyway.
Thank you. And it sounds like Ms. Moore has something to add to that.
I would like to agree. I don't think our discussions, we had a specific suggestion on how to address this, but generally, we have a lot of complex appeals that take 2+ years. And so I don't think that the data collected at the application point is really the best way to collect that.
Thank you. My second one was on the simplification. I understand that the confusion can arise when taxpayers know they have a Prop 19 issue, but they don't know how that translates to the appeal form. To what extent would Prop 19 justify a reevaluation of the appeal application form sections to assist taxpayers in completing the form more efficiently? It looks like Ms. Moore wants to weigh in. Go ahead.
I mean, overall, your average tax payer does not know what Prop 19 means. And so when we throw around language like that, in addition to the already complex, which box do I check in 5, and therefore which box do I check in 6, I think overall, plain language, they need to understand what they're looking at. So it's the same recommendation. We need to be able to explain to our taxpayers what exactly they're needing to select for each appeal type.
Thank you. Madam Chair, go ahead.
Thank you. I have a question for Ms. Moore. You said that my understanding of what you said was that the application can't carry the weight of correct contact information over time. And so how would that correct contact information be communicated going forward?
We ask our, filers to update over time, notify us. I mean, if you're going to move or somebody is going to step in and we're going to notice you, we obviously need the correct contact information to make sure that you get your hearing notice within, statutory guidelines. So the expectation is similar. If there's, a differentiation or something changes along the course, you need to notify the clerk's office. And I think this is a similar circumstance. So I don't know if the BOE wants to move forward on a separate form, or whether it's just, like Mr. Parker said, a duty of notifying the clerk's office. We can't easily track down updated contact information, and so it needs to be on the parties to let us know.
And so how exactly do people update their information, or say that it's a business and people are cycling in and out? How do they mechanically do that?
Currently, we get phone calls, emails, letters. I mean, it's a variety of different ways. When they don't notify us and we get return notices, we do our best based on the information that USPS provides us. But oftentimes, if it says undeliverable and there's no additional information, we're at a loss. And so, at least from hearing perspectives, they end up coming down later on a validity hearing because we've dismissed it for non-appearance. So it's up to them to notify us, and we take that update in any way that they provide it.
Mm-hmm. And then I would assume that if after a certain period of time, any refund would be escheated to the state and would be waiting for that person or that entity in some way.
And I actually can't speak to that because once we do our, final orders, we pass it off to the assessor's office, and then it goes to, the TTC and the auditor and controller. And so I think they'd be better to speak to that point.
Okay, thank you.
I believe that Ms. Tran has her hand up.
Thank you so much. Thank you so much. I just wanted to add to what Mr. Parker mentioned with regards to claim of refund. So last year, as I previously shared on my prior testimony, our LA County Board of Supervisors made a motion on directing the property tax departments to do an analysis on how we can streamline the appeals and refund process. Currently, we are making a lot of progress with regards to streamlining the appeals and of course the refund process. But one of the action that we are currently working on right now is with regards to payment records. So our plan right now, or we are trying to explore the possibility of creating an interface file transfer to TTC to let the TTC be aware or know with regards to payments or properties that have open appeals or pending open appeals, to exempt those tax payment records to their record retention policy, since the property or the tax payment actually has an open appeal with AAB. I just wanted to add that.
Thank you. With that, let me go to Vice Chair Gaines. I believe you had some questions as well.
Yeah, that's great. Yeah, thank you. I was just wondering if Thomas Parker, to just provide a little more clarity. You had mentioned in your introductory comments about the quasi-judicial nature of an AAB hearing, and therefore the scheduling ought to be prioritized with the clerks. And so I just was wondering, can you expand on that a little bit? And since you've kind of represented both assessors and appeals boards, what is the issue or the pushback coming from an assessor in that statement that you made?
I'll be glad, Mr. Gaines, to respond. The pushback comes from who's ready and who's not ready in terms from both sides, applicants as well as assessors. How ready are they or unready are they to present their case? Given all the work, if you look at the assessor side for just a second, assessors' offices don't exist, of course, just to handle appeals. There's all the work that they do that lead to the assessments that may lead to a challenged assessment at the end of that particular process. And so assessors, since they have to produce the roll every year and they have to track and chart new construction, and they have to send out escape assessments when they discover there's previously unassessed property. All that is, run-of-the-mill work, and on top of that, assessors have to then defend their challenged assessments in the AAB process. Applicants, on the other hand, it may be a very, as Chris O'Neill likes to say, complex appeal. And maybe it's a huge office building in downtown Sacramento. And there's a lot of money at issue, a lot of information to be prepared, appraisals, income approach, what have you. If the applicant wants to be ready in order to present their case properly, and if they're not ready, they are certainly in Los Angeles, they're not afraid to, one way or another, tell the AAB system that they need more time. And I'm sure they tell the assessor that too, but I'm guessing, I'm not a party to those conversations. So that's kind of the pushback there. Now, as far as the use of the term quasi-judicial, the California Supreme Court, in a number of published cases, as have intermediate appellate courts in a number of published appellate cases, used the term quasi-judicial administrative hearings, end quote. Now, let's talk plain English. What the heck does that mean? That means that assessment appeal boards are granted by the Constitution the authority to interpret law and regulations, apply those laws and regulations, and determine facts from evidence submitted, just like a superior court would. So that is what they mean by quasi-judicial administrative. And what's that mean? That means that courts, everyone knows this, but at the risk of saying the obvious, courts have to treat both parties in front of them equally and impartially, apply the laws, make the factual determinations necessary to resolve the dispute, and render a decision. And that's what, in the property tax context, the Constitution assigns to assessment appeal boards or local boards of equalization where you don't have an AAB ordinance. And so that's what I mean by quasi-judicial. If I haven't been clear enough, Mr. Gaines, please let me know and I'll make another attempt to be plainer as I need to be.
No, that's excellent. Thank you. I appreciate that. And you had also mentioned that there could be unintended consequences of changing the application. But we've had some recommendations given for changing the application. So I'm just trying to wrestle with that in my mind. Do you create additional litigation by trying to provide clarity for an applicant filling out an application?
No, sir. No, sir. And let me clarify my reference to unintended consequences. Clarification, simplification, whatever word is the best word to use, is good. And it better informs the applicants as well as agents and say attorneys who are not as familiar with the property tax world as others might be. But we want to be careful not to go beyond simplification and say, well, while we're amending this application form in the name of simplification, let's not add more to it. Because we have the opportunity here, right? This is a vehicle that it could happen. For instance, adding additional information that is going to confuse parties.
Okay.
So
Yeah,
that's
helps.
my point.
That's great. Thank you. And then if I could, just a question of Ann Moore in terms of the prioritization for scheduling lies with the clerk. How's that working with the assessor in terms of coordination?
Well, in our county, we have a really close relationship with the assessor's office. And to give you a little background, before joining the clerk of the board, I spent 11 years in court administration in King County in Washington State. So I have a lot of experience in calendar management. We work very closely, and I'm speaking from San Diego's perspective, with the assessor's office on availability, on understanding, in our current situation, we know which assessors are generally handle which type of cases, and we try to group those and schedule those in a way. But if it comes down to the assessor wants a specific day and the party just wants a specific day and they don't match, that's not something that we can weigh and determine who's right and who's wrong. So it's really, when they notify us that they're ready to go on this hearing, we already have kind of an expectation of what hearings are going to be heard when, as far as hearing types, commercial versus residential, et cetera. And we try to work around that. But at the end of the day, it's, we're at a 2-year time frame. Our party's ready. We need to proceed. And so we as clerks need to be able to manage our calendars so that we can get people to done as quickly as possible, because that's really what the taxpayers are looking for.
Mm-hmm. Okay, good. So Assessor Marks works with you, and
We have a very good relationship with our assessor, yes.
yeah, very good. Great, thank you. Appreciate it.
Chair, I'll ask a follow-up question. I don't know if go ahead.
Yeah, thank you. Well, it's a question for our executive director. I know that within the agency, there's a forms review process, and I'm wondering, have these 2 questions on the intake form come up there?
Good morning, Chair Lieber. David Young, Deputy Director of the Property Tax Department. You are correct. We review all our forms every single year. We just sent out our initial letter contacting county assessors and our partners in review, and we actually do look at the assessment appeals form. And I personally have taken a look at section 5 and 6.
Okay, and has the determination coming from the agency been that it's sufficiently simplified, or does it need work?
We're always looking for additional improvement, anything that would make the process easier, more clear. We're always looking for incremental improvements.
And so the plain language would be generated by the forms working group?
Ultimately, we would propose an amendment if there is one. We take in all the comments that we get in our review, and of course, the testimony that's happening right now. We take all that in.
Great. And is moving the instructions to the front rather than the last pages of the form, is that a non-controversial change?
It's less controversial if all you're doing is moving it front to back. There is, and the point has already been brought out, there is a cost-benefit analysis into how much you change the form, how much longer you change, how much longer the form becomes, how truly thick that instruction is at the end. At a certain point, some of the changes can outweigh some of the benefits. It's just a whole lot of folks, when they get that, sometimes that initial feeling of looking at a 15-page form may actually be enough to sway some folks. So we do take all that into consideration. We're trying to be as judicial as possible, weighing the cost and the benefits. And of course, we're also very aware that when we change a form, there are administrative costs to our partners in changing it. For some counties, it's easily absorbed. For others, it could be quite a challenge.
Okay, thank you.
Of course.
Member Vasquez?
Yes, how we doing on?
We're doing fine on time, but Mr. Schaefer has his hand raised.
Oh, okay. And then we'll go to our deputy clerk, our controller here. Go ahead, Mr. Schaefer.
Yes, there's some discussion about refunds being made available and maybe some difficulty in locating the property taxpayer. I would assume that people have 3 years before it would escape to the state, and that we would be notifying the controller of any refunds that had not been claimed. Is that going on, and is to further protect the taxpayer? I don't think we'd lose any taxpayers, because the refunds are going to people that own real estate, and they would have a good address of record, I would assume. But I don't know. Do we have any quantifiable amount of money that is to the state because they're just not claiming it as a taxpayer? Anybody know, understand that? What happens if we send a refund check out to somebody and it's never cashed?
Well, Mr. Schaefer, to try and answer your question, sir, the money would, if a refund is not received by the intended recipient that we know of, or we don't have an address, the money will sit at the county level for a certain number of years. And then under the government code statutes, I forget, it may well be 3 years, I'm not sure, I don't remember now the exact period of time. It will be sent up to the state, where the state controller's office controls the state escheatment process. And the state controller has to use whatever information they have access to give notice to the recipient of that money that, hey, you're owed money and we're holding it. right? And if the state, after a certain period of time and notice, you don't come to the state and say, hey, Mr. or Ms. Controller, I'd like my money, please, then that is cheats to the state.
Yes, I would imagine that we have a good address or presumably good address on every refund because we're dealing with people that own real estate. Am I right in that presumption?
Well, you're often right, Mr. Schaefer, but I can tell you that it's not always that way, especially with businesses and partnerships. Businesses and partnerships in theory can last forever, but as we all know in real life, that's not always the case. For various reasons, a business or a partnership disappears.
I say,
And,
yes.
and especially now, with incorporated entities, to wrap up a corporation, of course, you're supposed to file certain information with the California Secretary of State's office, which provides a contact point for the now defunct corporation. That doesn't apply to partnerships. So you have partnerships of 2 or more individuals, real live human beings that held property as an ongoing partnership at some point. The partnership disappeared for any number of reasons. Now a refund is owed to that defunct partnership, but it doesn't exist anymore. What do? There's no way to easily track down the people, if they're still alive, who made up the partnership that is now defunct. And that's not just theoretical. That's real life. I can tell you, Los Angeles County is in litigation right now in a partnership situation where the partnership that brought the appeal and is due the refund went defunct. And there are subsequent.
Is a lot of money being involved, and we're not just talking about a couple $100s?
It's business property, sir. It's a good chunk of change. Yes, sir.
Oh, thank you, and it's always nice to see you, as we do often.
Good to see you, sir. It's a pleasure to appear before this board and all the members. Thank you, sir.
Thank you. I think we have a question here from our Deputy Controller, and then I think the Vice Chair has one last question. Go ahead, Deputy.
I appreciate that, Mr. Vasquez. So I want to go and focus my question on topic 2, good cause. Prior testimony indicated AAB members often grant postponements almost universally due to uncertainty about good cause. So would providing a framework of what constitutes good cause and what does not constitute good cause improve consistency without imposing rigid bright line rules? And I'll open that up for all the panelists.
Like Ms. Moore wants to take it on first.
Absolutely. I think that anything where we can give our board members, especially those who are not attorneys, confidence in making a determination, that it will be helpful in, honestly, in allowing them to say no at times when it isn't a reason that is appropriate. I mean, as we all know, good cause is a legal term of art, and with as much training as many of these board members need when they come in, not all counties have the resources to provide that training, or they don't have county counsel in the hearing room with their boards during hearings to assist with those decisions. And so providing these guidelines would especially help those counties that don't have the resources for that. Attorneys, if they're going to participate in these boards, are taking time away from their billable hours. So it is more difficult to get, at least from our perspective, attorneys on assessment appeals boards. And so a lot of boards are made up of, other professionals, and this really is a legal determination. So this would assist tremendously in that.
Appreciate that. And if there's no other panelists, I have one other question in regards to topic 3, scheduling and exchange of information. Current law requires exchange to be within, I quote, reasonable time. Is that standard too vague to enforce meaningfully? And is there reform needed around what it actually means to be within reasonable time?
You want to take that, Ms. Moore?
I would just defer to the group. I don't think that we have a consensus from CCBSA on that topic right now.
I can't see hands of the other members, but I don't know, Ms. Taylor, are you able to see them better than I can? I don't know if anybody wanted to weigh in.
It looks like Mr. Parker would like to weigh in.
Okay.
Thank you. I would say a reasonable time, as a lawyer myself, obviously, and somebody who has practiced law for this is my 40th year now as a licensed attorney. Reasonable is a really vague standard. And going back to Mr. Gaines's question, given that AABs operate as a quasi-judicial entity, admittedly administrative, but still quasi-judicial, I think there is inherently a degree of vagueness in what is going to be reasonable in any given appeal situation where a postponement or a continuance is asked for. And it's going to require discretionary judgment, hopefully informed judgment, but still nonetheless judgment and not an automatic rule or mathematical equation type of approach. So, and I've said this before and I apologize, but I think it bears in this particular instance, saying again, you're going to have to look at the circumstances of the particular appeal. For instance, how many times have continuances or postponements been granted in the past? Is there a really good reason given by the party seeking the continuance or the postponement? Hopefully it's not the dog ate my homework sort of basis. If you have parties, meaning the taxpayer and the assessor, in disagreement over what information needs to be exchanged between each of them, and you're not talking about a formal exchange under Rev and Tax Code 1606, that's going to hang up the preparation of both sides in getting ready for the appeal hearing. And those are just a few examples. It's necessary a subjective, factually informed decision making, and I don't know how you escape the nature of the subject in general, at least in my view.
Appreciate that, sir. And Mr. Vasquez, if I may, I like to go around to each panelist here because we're running short on time. Just a yes or no would be fine. Do repeated continuances in complex cases materially crowd out smaller taxpayer appeals? Yes or no? We'll start with you, Ms. Ann.
Yes.
Mr. Parker?
Yes.
Yes.
I think you're on mute, last panelist.
I'm sorry, and yes.
Okay, thank you.
Thank you. Looks like Vice Chair still has another question or two here. Go ahead, Vice Chair Gaines.
Yeah, it was suggested, I believe, by Leslie Park about just getting larger print for the instructions. And I mean, is that something that we would do through our form? We've got as a sample form we're working on here, but could it be formatted so the print was larger so it'd be easier to read for an applicant? And is this available online also? And could it have larger print online versus a paper copy?
Once again, David Young, Deputy Director, Property Tax Department. Thank you for that question. We prescribe the content and the format which it's in. We can actually put it in larger print, but you are correct. It is up to the assessors to actually put it online. when they format it, it may turn out a little bit differently. And if they print it out I'm sorry, not the assessors, the clerk of the boards, how they decide to print it out and how they decide to post it online. But we prescribe the actual format itself and the content, so we can control part of it, but ultimately there is some discretion on the at the clerk side.
Okay, that's great. And then I just have a broader question in terms of, we have a working group here. Will there be a meeting of interested parties that will get into the nitty-gritty? Because there's a lot of great ideas and suggestions here, but I'm wondering, it seems to me that an interested party group could refine it and figure out what the priorities are. I mean, we're discussing these in a public hearing, but is that next? I'm just trying to figure out what is the process. Because I know we've got a working group here, and that's fantastic, but I don't want it all to just go into the atmosphere.
My hope is that after this, we're gonna go back through our notes and stuff, and hopefully there's areas where we see consensus. We'll bring it back and make
Okay.
recommendations to the board and invite participation from all the participants. We've had several folks, some that have left their positions but are still involved in some capacity, and we'd love to get their take and input on this, hopefully to help streamline this process.
Okay,
And in some cases, like on the refund thing, is an issue of, how do we expedite that?
okay. Does it go to an interested parties group of clerks and assessors
Yes.
that would then refine it
That's my hope.
or make changes or whatever? Okay, good. Let's try and
Oh, Chair.
understand
Lieber,
it.
go
Thank
ahead.
you.
Yeah, I want to make sure that we're raising reasonable expectations among the assessor community and the other stakeholders who are involved, that we do have to respect the processes that we have at the BOE, including our disability council and others. So I don't want to hold it out immediately that there's going to be an interested parties process until we take a look at what our normal process is. And here's our executive director.
Yvette Starr, Executive Director. I was under the impression that this work group was acting like interested parties, that the work group was providing their comments on what they wanted. And then your staff was going to put together a report and with suggestions that will be distributed to the entire board.
Yes.
And the board will make a decision on which one of these suggestions we want to direct the executive stars to implement.
No, maybe I wasn't clear.
Yeah.
After all this, we'll take it back, bring it to the board, and where there's consensus here, we'll bring it,
Then
we'll
you
put
bring
it
it to-
out.
yeah. Yeah.
I'm sorry, I don't know if that answers your question.
Would that assume that we would have buy-in by the Clerks Association and the California
I
assessors?
will assume that Member Vasquez's staff is going to continue to communicate with them and
Yes.
see
Okay.
if they are coming to an agreement. I mean, unless they want to come for another open meeting, but they're quite busy. But I'm assuming you guys will coordinate that.
Yes, we're hoping that, as we're putting it all together, especially areas that we think that might not have the full consensus of not only what we've discussed here, but of some of the other state partners that we've been working with, we'll run it by them before we share it with you folks, and
Yeah,
then
good.
see if there's a consensus here.
Excellent. Okay, that's great. Thank you.
Seeing no other questions from the group here. And I know we ran a little bit over on our little break, so I guess my question is to staff, do we want to take the lunch break now, or or do we move on? I want to be sensitive to our note takers here.
Yes, we
We
can
do it
take the
now?
lunch break now. We still want to go out to the AT&T operator?
Yes, let's go ahead and do that.
All
Let's
right.
close it out, and then we'll go ahead, we'll take our lunch break and then come back for the afternoon panels.
All right. We do not have any written comments, and we do not have any additional requests to speak on this item. Will, AT&T operator, can you please let us know if anyone is on the line that would like to make a public comment regarding this item?
Yes, thank you. If you would like to make a public comment, please press 10 at this time. 1 followed by 0. And nobody is queuing up.
And we have no other written comments, right? I know they handed out some things, but actually, most of those were actually delivered by the
Correct.
folks on the screen or in person.
That is correct. Those materials will be available on the board work group webpage on the BOE website.
Thank you. And with that, I'm looking at this, my clock here, it says 11:39, so we're going to give ourselves an hour. So, I'm sorry, Chair?
Yeah, and just a thank you to everyone who's participated in the first panel and to you and your staff for putting this together. It's very valuable input, and we definitely heard you loud and clear about things that you would like to see and things that you would not like to see. So thank you so much.
Yes, thank you all. And you're all welcome to stay on for the afternoon. We'll have other folks coming on, some in person and some again in Zoom, and we'll convene that. And as I'm looking at it, we have 11:39 here, so we'll regroup at 12:39. Thank you all.